You're watching a congressional ethics hearing where a lawyer admits he's had his client's case for 2.5 weeks but hasn't sat down to plan witness interviews, hasn't gone through documents properly, and filed a motion based on 2 or 3 hours of preparation. Then he asks for more time while the committee counsel warns they're running out of calendar days before an election blackout period. This isn't a routine procedural dispute. It's a congresswoman facing summary judgment on allegations that she funneled money illegally from Trinity Health Care services into her campaign, violated FEC rules by directing money movements, and made repeated compliance violations that resulted in an FEC settlement requiring professional staff and remedial training. Her lawyer just told the committee he needs time to sit down with my client and come up with a list of witnesses. The committee member asks if he's done that already. Answer: no, hasn't had a chance. Had the case for 2.5 weeks but hasn't arranged witness interviews or prepared real responses. He attached an affidavit contradicting staff evidence, an FEC settlement agreement, and a spreadsheet he says is the most important document, but unfortunately touches upon the criminal case. The committee counsel responds that giving more time is a little unrealistic, given House calendar realities and the June 24th blackout period, 60 days before an election where the respondent is a candidate. They need time for adjudicatory hearing, sanctions hearing, and a resolution for the entire House. What you're about to hear is how an ethics case against a sitting member of Congress is being rushed to beat an election deadline while her lawyer admits he hasn't prepared a defense.
I've had a request for one additional question from Mr. Ivey, and then Ms. Henson wishes to make a statement. So, Glenn, you're recognized. You go ahead.
Okay. Thank you to both of you. I want to see if I can tease out where we are with respect to the stay versus continuance. So the stay, I think we've kind of argued past that because just the length of time and the issues that are raised with respect to the Fifth Amendment challenges and the like. The continuance piece, though, let me ask why do you need additional time? And I want more specific than there's a lot of documents out there and I need time to go through them. What exactly would you like to try and do to address the issue with respect to disputes with respect to material fact that would be relevant to the motion for summary judgment? What exactly are you trying to do, and how little time could you do that in?
Thank you, sir. The very first thing I would do would be to sit down with my client and come up with a list of witnesses to interview, to offer.
I don't want to get in your attorney-client privilege piece, but I bet you've done that already, right?
No, I haven't.
Haven't had a chance to do that with her?
So I've had the case for 2.5 weeks. We have not arranged for witness interviews.
Not witness interviews, but just with respect to talking with her about what time. Okay.
No, we've talked, but I need to get people into the office. I need to set up interviews.
All right.
We need to work on the case. We need to go through the documents and prepare responses. None of that has been done, not really.
All right.
We did our best in 2 or 3 hours to put something together, but she deserves a real response to this motion, and in order to do that, it's going to take time.
Okay, and then the documents that you did attach to the motion you filed, I think these are the documents you attached. Can you tell me briefly what the relevance? You got an affidavit. I saw a notice of a settlement agreement, if I recall correctly. There was a document on there that was too small to read for an old eyes like mine. What are the points that are raised in those documents that would be relevant to the motion to dismiss?
To the summary judgment motion.
Yeah, I'm sorry.
Yeah. First, you have an affidavit in there that is contradicting evidence that staff was relying on in their summary judgment motion, saying that that did not happen. I was a witness to that, and I saw it differently. So that is a conflict in
what is the that?
The specific disagreements?
I mean, it doesn't have to be all the way in the weeds, but give me a general sense of what the disagreement is.
Disagreements about why money was moved, for example, from one account into another, how loans were made, who was responsible for directing those transfers of money. You have staff has a witness who's claiming that the congresswoman purposely put money into an account and then withdrew it in violation of FEC rules and regulations. And my understanding is the witness is going to say that that's not what happened. The congressman never directed that for it to happen that way. It was done by another individual.
Is that the affidavit, or is that?
That's the affidavit. Okay. I mean, I don't, I mean, to be honest, this is, part of this is just having the case for 2.5, 3 weeks.
I'm not trying to pick it apart. I'm just trying to figure out what the documents were and the relevance of those to the motion.
Yeah, the other things that we attached was the fact that many of the complaints that have been alleged by staff were also investigated by the FEC. And they had to do with the fact that this was the congresswoman's, for example, the most recent ones, maybe her first successful election, and having volunteers handle things like financial reports and not having a professional compliance team on board. So lots and lots of different mistakes were made, and a lot of those mistakes are reflected as complaints of the violations. The information...
That's the settlement agreement, the FEC settlement?
There was a settlement agreement where the FEC referred the congresswoman to alternative dispute resolution, indicated that she needed to hire professional compliance staff in the future, that somebody had to undergo remedial training on the necessity to file certain financial disclosures, all of which has been done.
Okay, and then that document that you have there is some kind of a... It's too small for me to read, but it was like a spreadsheet. What is that?
It's huge. That's the most important document, and that's a document that unfortunately touches upon the criminal case, which is one of the reasons why it's troublesome for me to get into it. But one of the major allegations that staff has made is that Trinity Health Care services funneled money illegally into the congresswoman's campaign, and that the congresswoman was just taking money from Trinity and using it for her campaign. Nothing could be further from the truth. One of the things that we filed, so that the committee has it in front of them, is the fact that she was entitled to a certain percentage of profits of Trinity, and the money that she was receiving from Trinity was not money that Trinity was using to finance her campaign. It was money that was legally obligated to be paid to her as part of the profit-sharing agreement, and those are the documents that were presented.
And I know I appreciate the indulgence of the chair. Could I ask counsel for the committee to respond to what they've heard? By all means.
I think much of what Representative Shervos McCormick's counsel has raised goes towards the motion to summary judgment, and we're happy to address it in that context. To the extent that he is raising a new motion, seeking some additional time, a continuance of a couple weeks, while that is procedurally improper, we're not objecting to him raising that now. And we wouldn't object in theory to the idea of a little more time, but we would raise some concerns about that concept. It's a little unrealistic given the realities of the House calendar and scheduling things. And then the blackout period that's been referenced would start in, I believe, on June 24th, 60 days prior to an election in which the respondent is a candidate. The process that we're undergoing is more than just one day. This involves a adjudicatory hearing at this time, but provides for a sanctions hearing to follow, and then likely a resolution for the entire House to consider. I think that the reason why we are here now at this time is because this is what puts the House on track to consider this in a timely manner before that blackout period begins.
Thank you, Mr. Chair.
Gentleman yields back.
What happened in that hearing wasn't just inadequate preparation. It was a demonstration of how congressional ethics processes compress time in ways that advantage expediency over thorough investigation, and why that compression matters when a member's career hangs in the balance. If you understand what the lawyer admits and what the committee is prioritizing, you'll see how election calendars shape accountability more than evidence does. Start with the preparation admission. The lawyer has had this case for 2.5 weeks. When asked what additional time would accomplish, he says the first thing would be sitting down with his client to come up with a witness list. The committee member asks if he's already done that. Answer, no, haven't had a chance. 2.5 weeks, and he hasn't arranged witness interviews or prepared substantive responses to a summary judgment motion that could end his client's congressional career. He admits the motion he filed was put together in 2 or 3 hours, and acknowledges his client deserves a real response. That's not a lawyer playing games or stalling. That's a lawyer admitting he's unprepared because the timeline didn't allow preparation. 2.5 weeks sounds like enough time until you consider what's required. Review potentially thousands of documents, interview witnesses, consult with client on strategy, research legal standards, draft responses to each allegation, and compile evidence contradicting staff's claims. For a complex case involving campaign finance violations, FEC settlements, and alleged coordination between a healthcare company and a congressional campaign, that's not remotely sufficient. Now layer in what's being alleged. Staff claims the congresswoman funneled money illegally from Trinity Health Care services into her campaign, violated FEC rules by directing transfers between accounts, and committed repeated compliance violations serious enough that the FEC referred her to alternative dispute resolution, required hiring professional compliance staff, and mandated remedial training. The lawyer's defense is that the money from Trinity wasn't illegal contributions but profit-sharing payments she was legally entitled to receive. That's a factual dispute requiring documentation of profit-sharing agreements, financial records showing the source of funds, and witness testimony about who directed what transfers when. The affidavit the lawyer attached contradicts staff evidence about who directed money movements. Staff says the congresswoman purposely put money in an account then withdrew it in violation of FEC rules. The witness says that's not what happened, that another individual directed those transfers, not the congresswoman. That's a classic factual dispute that summary judgment is designed to identify. If there's conflicting testimony about material facts, summary judgment shouldn't be granted. But the lawyer can't fully develop that conflict without time to interview witnesses, obtain additional documentation, and prepare a comprehensive response. The June 24th deadline is the structural constraint that makes this all make sense. That's 60 days before an election where the congresswoman is a candidate, which triggers a blackout period during which ethics actions can't be taken. Committee counsel says the timeline they're on now is what puts the House on track to consider this before blackout begins. But consider what that means. They need an adjudicatory hearing, a sanctions hearing, and a full House resolution, all completed before June 24th. Working backward, that means summary judgment needs to be decided now, which means the defense needs to be complete now, which is why the lawyer only got 2.5 weeks. This reveals how election calendars drive ethics processes. The blackout period exists to prevent ethics charges from being used as election interference. But it also means that charges filed close to an election must be resolved on compressed timelines that may not allow adequate defense preparation. The congresswoman is being held accountable on a schedule determined not by how long investigation and defense require, but by when voters go to polls. Committee counsel acknowledges this tension. He says they wouldn't object in theory to a little more time, but raises concerns about realism given House calendar and blackout deadline. That's an admission that the process is calendar-driven rather than evidence-driven. If the case requires more time for proper adjudication, but calendar constraints don't allow it, the system prioritizes schedule over accuracy. The criminal case reference adds another layer. The lawyer says the spreadsheet showing profit-sharing entitlement unfortunately touches upon the criminal case, which makes it troublesome to discuss. If there's a parallel criminal investigation into the same conduct, that creates Fifth Amendment complications. The congresswoman might have valid reasons not to provide certain evidence or testimony in the ethics proceeding if it could be used against her criminally. But the ethics process is proceeding on its own timeline regardless of those complications. What's the systemic consequence? When ethics investigations are rushed to beat election blackouts, members facing charges can't mount adequate defenses, evidence doesn't get fully developed, and outcomes depend more on timing than on whether violations actually occurred. That's not accountability, that's schedule-driven adjudication. And when it results in sanctions or expulsion determined by calendar rather than facts, both the accused member and the institution's legitimacy suffer. If any of this concerns you, recognize that ethics accountability requires time for both investigation and defense. When election blackouts compress that time, you're not getting justice faster. You're getting justice with less evidence, less scrutiny, and more risk of error. The question isn't whether this congresswoman committed violations, it's whether the process gives her a fair chance to prove she didn't before her career ends.